Good afternoon. I'm Tim Opsitnick, the Executive Vice President and General Counsel for TCDI, and I have the privilege of introducing our webinar, panelists, and our moderator today. TCDI is a litigation management, eDiscovery, and document review company. We are our patron sponsor of the Rabiej Litigation Center, and we have been a supporter of John and his center for many years. This is the third in a three-part series of webinars. The first two examined the meaning of relevant for discovery purposes and the feasibility of joint training of TAR and generative AI search tools. This webinar will explore the inevitable transition of generative AI into a standard search tool while examining the critical hurdles likely to slow its widespread implementation, particularly in mass-tort MDLs. Our moderator today is John Rabiej. John founded the nonprofit Rabiej Litigation Center in 2022. Prior to that, he partnered with George Washington Complex Litigation Center for 2 years, and prior to that, he was with Duke Law for nearly 7 years. Previously, Mr. Rabiej was the chief of the Rules Committee Support Office for 20 years, establishing and heading the office that staffed the 6 rules committees of the United States Judicial Conference. The panelists for today's webinar include Dr. Aron Ahmadia, who is the Vice President for Applied Science at Relativity, where he leads the development of AI capabilities for Relativity 1, including AI-assisted review, case strategy, data breach response, contracts, and information retrieval. Our next panelist is Steve Goldstein. Steve is a seasoned legal technologist with over 30 years of experience at the intersection of law and technology. He is a recognized expert in eDiscovery. He has pioneered cutting-edge solutions from the early adoption of predictive coding to today's innovative work with generative AI. Steve joins us today from Altorney, an AI eDiscovery company. Our next panelist, John Rosenthal. John has more than 30 years of trial experience. He litigates complex commercial, class action, and multi-district litigation, and has substantial experience defending clients before federal and state enforcement agency. John has comprehensive MDL and class action litigation experience with extensive experience in areas of electronic discovery, privacy, information government, and data breaches. Our last panelist, and certainly not least, is U.S. Magistrate Judge Gary Jones from the U.S. District Court, Northern District of Florida, where he has served since 2010. Judge Jones is well known for his involvement in educational conferences and scholarly contributions concerning eDiscovery. Welcome to today's webinar. John?
Thank you, Tim. I also want to thank our panelists for agreeing to speak on these fascinating issues. Now, while I was staffing the Advisory Committee on Civil Rules back in 2000, the committee was grappling with proposed amendments to Rule 26 intended to rein in the explosion of discovery. When the committee first spoke of exploding discovery, we were dealing with 100,000 documents. But the committee knew, even then, that the move toward ESI would eventually make these volumes look small by comparison. After many unsuccessful rule drafting attempts, the committee came to the realization that only technology could solve the problems that technology created. Now, fast forward to 2012, when the committee turned to RAND to evaluate the promise of TAR. RAND issued a comprehensive report which concluded that TAR would slash manual review volumes. But those expectations have yet to be met. Boolean keywords continue to be the default standard in mass-tort MDLs and numerous class actions, while the production of millions of documents has regrettably evolved into a baseline expectation for many in the bench and bar. Now, generative AI might be the technological solution that the committee was hoping for, but it raises a pivotal question. Will widespread use of AI trigger a permanent increase in the production of, quote, conceivably relevant, end quote, information across a constantly expanding range of devices? Or will it be used to limit production by prioritizing documents that are truly important in resolving the case? The predominant Rule 26b1 proportionality factor. Now, we might be at a critical juncture. AI can cast a wider net by rapidly processing complex data such as Slack messages, Teams chats, and audio transcripts, lowering technical barriers, but risking a future where relevance translates into the production of tens of millions of documents. Now, this creates a significant dilemma. AI can fulfill the Civil Rules Committee's vision of reducing front-end volume by identifying documents based on their importance to the needs of the case. But its robustness also allows parties to easily manage massive data dumps by applying their own AI tools at the back end. This allows them to identify what they deem important rather than relying on their opponent's AI prompts, which are kept secret. The result is unsurprising. Current incentives favor the back-end strategy. From a strategic perspective, few are willing to accept even a marginal risk of omitting a key document through precise upfront screening. Instead, parties default to exhaustive, keyword-based overproduction, knowing that they can simply use their own AI tools to review the resulting data dumps on the back end. Today, we are privileged to have this distinguished panel share their expert perspectives on the future of AI and eDiscovery and evaluate whether the Civil Rule Committee's vision that the proportionality amendments would lead to more reasonable discovery can be achieved through this technology. We will focus on large class actions and mass-tort MDLs like the 3M Combat Arms Earplug MDL, where more than 11 million documents were produced. But the lessons learned may apply equally to many other types of cases. Each of our speakers will have roughly 10 minutes for remarks. We will try to respond to any questions that you submit on your screen during the webinar. For those seeking CLE credit, please be advised that I will pose a specific question sometime during the presentations. Your response is required to verify your active participation. Certificates of accreditation and attendance will be forwarded to you after the seminar. Also, this webinar is being recorded, and a recording will be posted along with the recordings of the 2 previous webinars on the Center's website. Center will continue discussing these AI issues at its Benchmark Class Action Summit at the Charleston School of Law next week on March 12th, and again at its mass-tort MDL Summit at Northwestern University on July 16th. Center also plans to hold a mass-tort bankruptcy summit at the new Wilmington University Restructuring Institute on November 19th. Please consider registering at one of the summits on our website at rabiejcenter.org/events/. Your support is essential for the Center to continue its work, bringing the bench and bar together to develop practical solutions to real-life litigation problems. We start now with Dr. Aron Ahmadia from Relativity. Now, Relativity is one of, if not the major eDiscovery vendor. Relativity Air is a suite of programs built on Microsoft's OpenAI service, which, among other things, performs document reviews. Aron, can you give us a general description of how the reasoning-based logic process of Relativity Air works and compared to the established processes of keywords and TAR?
Thank you so much, John, Tim. Real honor to be here. Thanks for the invitation, and I'll try to get to the answer right now. So it's always funny. I'll start with another sort of statement that a lot of people sort of have bandied about in the past. It's like lawyers are slow to adopt technology, and I think that answer is completely wrong. I think lawyers are always willing to adopt technology that gives them some sort of advantage or helps them sort of solve a problem that's there. And I've seen this, obviously, we've seen this in the last couple of years, the adoption of generative AI. But But keywords and TAR are another example of a technology, natural language processing, and Boolean search before then, that were really not that used in many other fields or in the enterprise, despite their great utility. And the basic idea of a Boolean search is that I have words that I'm looking for and words that I'm not looking for, and sometimes phrases that I'm looking for and phrases that I'm not looking for. And so if a document contains a phrase or a name like Aron Ahmadia, I can say, well, find me all of those documents that have Aron's name in it. TAR is a generalization in some sense of Boolean search, where instead of sort of saying, hey, I want documents that have Aron's name in it, I will say that a document is more important or more likely to be important if it has Aron's name in it. But if, for example, it was a conversation with, I will pick on Judge Jones since he's on the call and he's here with me, perhaps Aron's conversations with Judge Jones were less relevant. And it's almost sort of like a fuzzy boundary that allows you to sort of declare a lot of things that might be useful and might not be useful. But the way to think of them is they're very almost statistical. TAR and keywords are about the contents of the documents, but they are not necessarily about how individual words or sentences or paragraphs appear, what order they're in. So for those of you who've been following the explosion of adoption of technology, generative AI and large language models ingest sentences directly instead of statistically. And then what I mean by that is instead of paying attention to the presence or absence of words, it pays attention to every single word in the order they appear. That includes misspellings. It includes titles, honorifics, punctuations. All of these things in some way are visible to large language models. And so small types of innuendo, like you can even have emojis, like little smiley faces and other things. These things can all be picked up by a large language model. Instead of the large language model being given, in some sense, example documents or a list of keywords, it's given a set of instructions just like a reviewer. And those instructions are then parsed alongside with the document that it's looking at to make this, as we said, relevance call in very similar ways to the way a managed review judgment would be made, or even a TAR classifier would once it's been trained. So that's the basic idea how it works. Again, some of the critical differences, or the two most important differences, one is that it uses a natural language interpretation of the text itself. The second is because it can be given direct instructions, it does not require, in some sense, training or seed sets or other things differentiating it from TAR.
It's great. Panelists subsequent panels will be talking about the results of error search, and as I understand it, it classifies documents for relevance in 4 categories: very relevant, category 4; relevant, category 3; borderline relevant, category 2; and not relevant, category 1. And in the 3M earplug MDL that I referenced earlier, 11 million documents were produced as relevant. When checked under Gemini and asked how many of those documents would they estimate to be very relevant, and the answer was about 1 million documents would be classified as very relevant. Now, is that estimate unreasonable? I understand that there's, you don't have all the facts, but is that a ballpark figure? Are you surprised at that number, small or large?
Yeah, no, it's a great question. So again, every matter is different. I think everybody here, both certainly on the call and listening in, is aware that there's this sort of baseline amount of documents that the attorneys typically expect to produce. And we call that number, and it varies by matter, the richness, or the richness is kind of the common term. And so if there really were 1 million very relevant documents, and this is, again, the target of the production, then we would say the richness is 1 million. What I will qualify here is that the definition of what should be produced is not something that we decide as a vendor or as a technology company. We are just here to help the the governing parties who have decided, or the searching party, the producing party, perform their reasonable search. And so coming back to, is 1 million very relevant documents unreasonable? It's actually a little high. One thing that we've noticed is that the large language models tend to be pretty selective about what they will call a very relevant document, and it will typically need to precisely match the exact definition of something in the review criteria or the relevance. Other than that, most documents tend to be relevant. And what we do find is that a lot of documents that the producing party feels they need to produce often show up in this borderline category.
The reason question was asked was the GenAI indicator was about 5% of the population would be very relevant, and 3M is 11 million relevant. So there's probably dealing with 22 million documents to begin with. And that estimate spurred on the question of how does relativity error deal with cumulative, near duplicate documents beyond deduplication. For instance, if thousands of very relevant Category 4 documents say the same thing, how do you guys handle that? And I understand you may have a special feature, structured analysis, analytics that can help out in that.
Yeah. The short answer is probably going to be a little disappointing. And the answer is that relativity does not sort of treat marginal information gain as something that is part of a sort of search process or a defensible search process. And so there are lots of tools when we talk about the broader field of information retrieval that will say, hey, if I have a question and I only need one document to answer it, then I'm going to go through a pretty exhaustive filtering process when I return the potential answers to that question. And so if I go onto Google and I type in a Google search and I get 20 results back, Google goes through some effort to sort of try to imply, they sort of what's called diversity, right? So they look at the marginal gain of information and they aim for diversity. So why doesn't relativity do the same thing? The answer has to do with the sheer volume and the exhaustiveness of search that is performed by producing parties. I keep flipping this. By the producing parties, which is to say, I'm trying to give you every document that might answer your question, and I don't know which one you want. And if these two are slightly different, there is a chance that this document is going to sort of be the one you want, and if I give you the wrong one, I'm going to get in trouble. Now, this is a US specific thing. There are other jurisdictions outside of the US where you're actually expected to only provide the most relevant document, but that sort of breaks this concept of four-corner search that the US has in most places. And again, I'm actually speaking a little out of turn as a vendor. This is my understanding of how the rules work. Feel free to correct me if I get anything wrong.
Yeah, no, I raised the question because if we do have a large number of very relevant documents that basically say the same thing, as I understand what you're saying is if I give you an example, if the issue is whether or not a person attended a meeting at the company's headquarters, and I have documents from 100 employees saying that I saw this person attend the meeting. They all say the same thing, different persons, so they're not duplicative. Relativity error would produce that as very relevant. That's that would be included in the very relevant category, and it would be up to the lawyers to determine whether or not they want to produce all 100 of the very relevant, or you apply another feature of relativity, like you're saying, a structured analysis gives you more information, but it's still classified as very relevant.
Yeah, no, that's really up to the person who's writing the review protocol for the product. So if you're sort of interested in the person's calendar entry that shows that they had a meeting at headquarters, then you could make that the sort of qualifying criteria for very relevant. And then somebody saying that they saw somebody might just be, effectively a marginal or borderline relevant document. So there's a lot of filtering and power just in terms of how the review protocol or the instructions to the model are written that allow you to differentiate what the model will consider very relevant. It's not making that decision on its own. It's making that decision informed by the criteria being provided by the attorney. And again, it's usually, there's a fair amount of effort that goes into developing this review criteria so that the right documents are produced. And if you only need one example of these hundreds of diary entries or meeting reviews, you can in some way sort of inspire the model to go after the one that's most useful for you.
Aaron, you mentioned that your platform for it, when you use it internationally, has different features. Would there be a way, maybe not now, but maybe in the future, underneath Rule 26, relevance or discoverability of documents is also limited by proportionality, and then the rule goes on to provide 6 factors to consider when dealing with proportionality. That's very difficult to apply by humans. Is there a way that you see down the road that those 6 factors, like the importance of the information, the party's resources, the other factors, would there be a way to do that using AI? Or have you guys even thought about applying those 5 factors to the 6 factors to the search?
Let me kind of tackle the first question and I'll come back. So the first question was, do we sort of have different features in different jurisdictions? And the answer is generally, we have some. Our AI features generally behave the same way. So if wherever you are in the world, you are, despite the only thing that changes is where your queries get sent to. We have regional AI capacity around the world to follow data protection rules.
Yeah.
But coming back to your second question of how we consider proportionality, I think that's still more of the attorney's concern and consideration and the producing party's concern and consideration than it is necessarily that's something that we would do. Our job is to be fast, to be efficient, to be accurate, to be aligned with what the producing party is trying to find. I don't think that we necessarily get, at this point, deeper in the game than that.
Thank you. That was very useful. Before turning to Steve Goldstein, let me pose the CLE question. What is the sum of 2 plus 2? You can enter the answer on the chat box on your screen. Now let's turn to Steve from Altorney and the co-founder of their Mark platform. Mark is an AI-driven platform that can perform legal analysis and classification tasks traditionally requiring human reviewers. Like Relativity, Mark identifies relevance, responsiveness, and privilege, and more. Steve, can you briefly describe how Mark operates?
Well, thank you for having me today. It's a pleasure to be amongst all of the speakers and you. Aaron gave us a good rundown of the Relativity product. We are similar in many ways. It is lawyer driven. There's inputs, not in the way of prompts as we would know them from using ChatGPT or other tools like that, but there is a review protocol, and sometimes it is the actual review protocol that a human team would be using, or it's a review protocol that is written for the Mark tool to do what it does. That's going to typically be an overview of the case. It's going to contain themes, issues, key people, significance events. Anything that you would instruct a human team on is the same thing you're going to instruct the Mark tool on. And then once it has that criteria, it's going to go through one by one across however many hundreds of thousands or millions of documents you have, and it's going to judge that document with that criteria in mind to determine whether or not it's relevant, whether or not it's privileged, whether or not it's responsive to a particular issue. It will pull out some key facts, and you can screen for PHI, PII, one document at a time. So it's a very thorough process, but again, it is driven by the lawyer ultimately to instruct the system on on what the criteria is for these various tasks.
Well, both plaintiffs and defendants generally agree that AI-powered reviews are superior to keywords or TAR, but the success of the process seems to depend on those prompts that are used to instruct AI to find responsive documents. Now, in MARC, this can be accomplished by drafting or having the system automatically draft the detailed criteria for relevance. Now, if relevance is supposed to be an objective legal standard, how easy would it be to manipulate the wording of the prompt to omit critical documents? Of course, this is a question from the plaintiff side. Typically, they're concerned that this is a black box. Defendant controls the black box. They can manipulate it to miss a keyword. How easy is that if you have an objective standard? Does the machine go around that and actually, even if the instructions are pretty precise?
It's as easy as manipulating a team of 40 document reviewers. It's no different in that. So ultimately, you're instructing either the human team or the AI tool to classify documents as to relevance based on a particular set of criteria. Now, if it is your desire to omit or obscure or to leave out or over include certain genres of materials, that is ultimately something that is in the control of the legal team, and it's something that has been in their control for 30 or 40 years. Right? I've done hundreds and hundreds of document reviews, and there's always an opinion as to we're not going to give them that. If they want it, we can fight over it. So the first instance of the training is like, no, do not give them documents that look like this. So these review protocols with the human teams are being manipulated and omitting things every day, and the Gen AI is really no different. It is human driven, and what the humans decide to put in are in fact subject to that kind of bias.
I guess what I was getting at is that despite the prompt, because AI is going to collect thousands, hundreds of thousands of documents, will it still get the relevant, the important documents, even if it doesn't really answer the direct prompt? The prompt will be very minimal and very narrow, but nonetheless, it's going through all these documents.
Although I would opine, I think Aaron would probably agree, and others, that these are designed to follow the instructions they're given. They're not going, if you say, I only want red, purple, and green, it's not going to say, nope, I read the complaint, I'm giving you, pink. It's going to do what it's told to do, the same way that you hope the human team is going to do that. Now, that said, and maybe we drift into one of the next questions that you might have, I think the most unbiased way to do this is to feed it the complaint, the counterclaim, the RFPs, and let it decide on its own without any emotion or strategy or intent as to, based on a reading of those materials, what is in fact relevant. And that is probably the most unbiased way to do it. However, lawyers do have duties and responsibilities, and I would defer to both you and John Rosenthal and the judge on those matters. But I'm not sure anyone's prepared to let the machines just decide that on their own, unsupervised.
But that does hold some great promise, just because of the reasons you just mentioned. It eliminates a lot of the concerns about bias. And I would think if such a process is followed, that you may develop a track record over some time that, in fact, these automatically generated prompts without any human involvement are pretty good. And that would give people confidence later on.
Yeah, I have no question that they're pretty good. The question is whether or not they are in tune with the strategy or the defenses or the approach that the legal teams would take to the matter.
Well, that's a good point. You're saying that, okay, it all depends upon the strategies. But if the task of the search is to find, it's an objective standard. And both sides should be aiming for the same thing. How much, in your experience, it may be limited now, but how much tweaking is actually involved in these auto-generated prompts, whether the lawyer says, we want to make some major changes, or is it tweaking?
So our system puts out a pretty thorough analysis of the summary, the issues, the themes, the people, the products at issue, and so forth. It's designed to be a first draft. It's designed to put in front of Counsel to edit, to make sure nothing is being omitted that really should be included. It's also equally as designed for them to take things out that they might not want or believe are necessary to be produced. So we find that the tweaking is usually light, but that tweaking does occur. And at that point, it is their work product, presumably, and they have put their thumbprint on what the criteria will be going forward in the same manner that they would to a human review team. Somebody's preparing a 40-page protocol and delivering that in a training session and going over examples, and then the team goes off with those instructions. This is no different in that.
When reading the promotional materials for Relativity Air, the prompt consists of 4 fields, and the recommendation is for the lawyers to insert 5 to 10 sentences for each field. So that's 40 sentences. That seems kind of slim to me. And what I've heard others talk about, these prompts are 10, 15 pages. Can you give us any insights as to, on your experience, based on how big? Obviously they probably range, but can you give us some?
I think there's a range. I think different tools approach it differently. I think at the end of the day, regardless as to what's coming in the front end of it, it all comes down to the results. No different than keywords and then TAR and predictive coding, and now this technology. The proof really is in the pudding. I mean, if 10 sentences is sufficient to achieve a particular level of accuracy that you need to defend the process, then that's great. If 15 pages does it better and gets you to a higher standard, then that would be what you might find to be necessary. But at the end of the day, no matter what you're doing, I would believe would need to be measured and work within the same defensibility parameters that we've established over the last 15 years, I think, Judge Peck and so forth, about recall precision, repeatable processes. And at the end of the day, it's really, if you get brought in before Judge Jones and then motion to compel and a document wasn't produced, are you prepared to describe why that document didn't make it to the other side? And are you comfortable, with that scenario? That's really, I think, what it comes down to. If 10 sentences get you there, then you're in good shape. But I think the end result is what probably matters most.
Well, thank you. That's been very useful information. We'll now move on to John Rosenthal, an experienced litigator. Now, John, in a massive production of millions of relevant documents with hundreds of thousands of documents classified in each of the 4 AIR categories, what role should the Rule 26 proportionality factors play in deciding whether to produce them, especially the importance of the requested document in resolving the issues? Here what I'm getting at is, can AI help to screen relevant documents for proportionality, and should all documents in AIR's categories 2 and 3, relevant and borderline relevant, and even 4, very relevant, be subject to the proportionality analysis?
So let's frame this a little differently, John, and then I'll get back to your question. You seem to assume at the front end that people are engaging in millions and millions of document review without the use of TAR or advanced analytics. I don't think that's correct. I think we have to level set what's going on in the larger complex litigation. Overwhelmingly in the larger complex litigation, search terms are being used to cull. They're being used to reduce the volume of information subject to ultimately some form of review, right? And the parties typically have some kind of negotiation. They may litigate over that, but those are culling. Search terms are not being used for relevancy determination in the overwhelming majority. It's simply to create a bucket of what they think is and create what's called a review boundary, right? Because part of the problem here is we have to agree what set of documents and information is going to be ultimately subject to review, whether it's manual review, TAR-based review, AI-based review. All right, so now let's move to the how we do the review. Now, the reality is that TAR had a great promise here. But the problem was that TAR got bogged down because requesting parties came in and insisted they wanted to control the process, they wanted to negotiate the process, they wanted to limit the process. So most of the defendants said, not a chance. And today, while TAR is still being used on the overwhelming majority of large document reviews and productions, it's being used for batching and organization. So you're right, the promise wasn't delivered, but it's a somewhat of a misnomer to say that TAR is not being used. It's being, up until about a year and a half ago, it's being used widely, certainly in large complex litigations. In my shop, almost 100% of the large reviews use some kind of TAR in the background. Now, for relevancy determination, to put things into buckets, is the bucket presumptively relevant or is it presumptively irrelevant? All right, so now comes along AI. Everybody who has looked at these engines, and let's leave Gemini aside, whether or not Gemini thought something was relevant is pretty much irrelevant. Gemini is not designed to do document review. And there's a difference between large foundational models like a Claude or a Gemini or a ChatGPT versus an engine like Relativity or Altorney, which is refined both in terms of its workflow, its training, to identify relevant documents, privileged documents, confidential documents. Totally different world. These engines are specifically trained and fine-tuned to actually do that and then work with the attorneys. Everybody who has used these tools pretty much agrees the tools work at least as well as human review, probably as well as TAR, if not better than TAR. Now, one thing you got to understand is a large percentage of the documents subject to like a large MDL or class action aren't ever going to be susceptible to this engine, at least not today, because they have size limitations. They don't work across the same across all kinds of documents and formats. For example, they don't work very well in chats. They may not work well in large Excel spreadsheets or Excel spreadsheets or that kind of data. So you're not going to be able to put all the eggs in the basket. For the eggs that you can put in the basket, it's going to work pretty well. But the difference here is, unlike TAR, where we're trying to argue over what a seed set looks like, and then the objective training of the seed set, and then validate it. Here you have the prompt. And the prompt's a very different thing because the prompt actually does reflect the attorney's work product and their mental impressions. So the idea that we're going to sit there and negotiate prompts, I don't think it is going to work. What I think we need to do is focus on validation. In terms of proportionality, getting back to your original question, I don't think these technologies change proportionality at all. We lobbied and were successful to get the rules committee to change the scope of discovery because of the amount of the information being put into the discovery pool. Just the sheer volume, as well as the diverse types and media types, it's exploded. So will this technology help attack that? Yeah, but that's not going to solve the proportionality problem. You're still going to have to draw lines of proportionality because relevance is just simply too broad.
So just digging a little bit deeper in that, if you run your search and you find 100,000 documents were classified as very relevant, are you going to go through them and apply the proportionality test, or are you going to produce them because they are classified as very relevant?
I'm going to produce them, right? The question is, am I going to review all of them? Because there's going to be an error rate, just like there's an error rate always. We know humans the average of humans between 75 and maybe 90% in terms of recall. The TAR engines, about the same. These engines, depending on the data type and the richness, appear to be performing as well, if not a little better. So we do know there are going to be false positives in that relevant pile. But I'm going to produce the relevant pile. Am I going to look at all of them? If you ask me today, yes. Am I going to look at all of them a year or 2 years from now? Probably not. I think the client's mindset is really changing on that.
Sure. Do you see any problem, though, in doing it in these massive productions? And there's going to be a massive number, I don't know what they're going to be, but in the very relevant. I got to guess that a lot of those documents in the very relevant category in a massive data set are going to be cumulative and don't say anything, don't bring anything new. And if you had the time, you could look at it and say, this is not proportional because it doesn't add anything here.
Yeah.
Now, would you go through the analysis, or just because it says very relevant, you're stuck and you don't want to fight it and it's going to go?
So you got to remember, in most litigations, we're taking the exact duplicates out off the top.
Right.
We're also still doing threading. So particularly when you talk about chats and email, which probably in a chain, if you were able to reduce the lessers, you're taking about 50 to 60% of the volume out of what you have to review. So now we're down to like Word documents, PowerPoints, those kinds of things that are near duplicates or versions. Today we're not going to worry about them probably that much. You just got to remember the receiving party's got the same set of tools on their end,
right,
to attack the review. So the idea that unless I'm engaging in boxcar discovery, they don't have the same burden claims that they probably used to. Frankly, everybody's been so focused on these new tools and they're moving so fast, they really haven't had a chance to figure out how do we combine them with some of the other traditional tools, such as near duping technology. And frankly, near duping technology, wasn't widespread and operated on a variable level. I believe these tools will also be able to attack the near duping issue in short order. But, right now they're trying to attack relevancy, confidentiality, privilege.
Let me ask you, because I'm going to ask this question to Judge Jones from the judicial perspective. From your perspective, when you're faced with a lot of documents that are classified in Category 2, borderline relevant documents, you're going to make a decision based on proportionality whether or not these things should be produced. When the dispute, if there's a dispute that comes over to the court, what kind of information would you think would be helpful to provide the court to make its determination to say, yeah, your decision was correct, these are not proportional?
Yeah, I'm probably not going to get there, John. My proportionality argument is going to be at the front end when I try and sit down with the plaintiffs and negotiate the scope of the review boundary. What custodians are in or out, what non-custodial sources are in or out, what are the date ranges, what are the search terms. If I can get to an agreement on that, I'm probably beyond the proportionality point. If I can't get it,
what would you do with the borderline relevant? What are you going to do with the borderline relevant, which apparently is a bulk of the cases that are classified? The borderline means it's kind of questionable. Do you have any feeling? Have you any whether you can produce all of them, or you got to go through all of them? Or
so even in large reviews, we haven't had an insurmountable amount of borderlines, and we do go through all the borderlines.
Okay, good. Hey, great. That was very interesting information. Let's now move to the judicial perspective. And incidentally, we will go to 5 minutes after 1, because to get CLE credit for the time, we had to add on 5 minutes to offset the 5 minutes introduction. So we'll go to 1:05. Judge Jones, in a massive document review, documents in Category 3 relevant and Category 2 borderline relevant may not be technically duplicative, but many would likely be near duplicate, cumulative, and would not add any meaningful new information. What information would you want from the parties to help you decide whether all or some of them had to be produced? And along the same lines, would you ever consider declining to order production of some Category 4 very relevant documents if they were cumulative. Judge?
Yeah, thanks, John. First, let me say this is not an issue that really comes up frequently, but if it did, one of the first things I would want to know is the volume of documents that we're talking about. If we're talking about, 500,000 documents in each pile, that's one thing. If we're talking about several hundred, that is certainly another thing. I would certainly want from the requesting parties a reason why both categories should be produced. I think that's the starting point. And as John pointed out, the way discovery works, it's really up to the producing party to make their determination of what documents they have to produce consistent with the rules. And, it's never the requesting party saying, oh, look, Judge, they missed this one document, because I'm sure everyone on this call will agree, eDiscovery is not perfection. You're not looking for every last document, but where there is a missing documents, that's where defensibility and validation come into play. And then, the burden shifts to the producing party. Can you defend your production, your review, and are there metrics to validate it? And if you can do that, then you have fulfilled your duty. In a really close situation where there was some evidence that the borderline documents, a good argument why they should be produced and they haven't been produced, there's always the option from a judge's perspective of an in-camera inspection of a sampling of documents. Judges don't like to do that. I can remember one time I did a in-camera inspection and there were like banker boxes delivered to my chambers. No judge has the time or the aptitude really to be reviewing, hundreds of thousands of documents. But, if you're able to have it, this really became an issue and you were able to target in on a sample of the documents in each category, and then a judge could take a look at it and make a judgment call. One other thing I think AI sort of adds to the equation is AI has the ability not only to tell you whether a document is relevant or not relevant or privileged or not privileged, it can actually highlight the language in the document, the portion of the document that the AI relied upon in making that determination. And certainly from a review end, if someone's looking at that, that really cuts down on time. In the rare situation where a judge is going to do an in-camera review, that's something that's really potentially beneficial rather than reading through a 17-page memo. Maybe you highlight, 5 or 6 paragraphs and you can zero in on what the document's about and why it should be produced or why it, should not be produced. One thing that John said that does make sense when you talk about, cooperation between the parties and how AI, the sharing of prompts between each side will make discovery more iterative and cooperative. The cooperation really goes on at the front end when the parties sit down and they disagree about things, but they negotiate, who are the custodians? What are the databases? Importantly, date ranges can have a huge impact on discovery. What are the key players? What are the key, concepts? They are things, in my view, all attorneys typically will negotiate. And then it is from that point, once you have, John called it culling, but once you have the universe of documents that you're now going to review, that's where AI really can provide a benefit, because statistically the recall rate is higher, and arguably can be less costly, not in terms of using the AI, but in how efficient it is. So that's where it can really make, in my view, that's where it can really make a difference, and has been making a difference. And as it gets better in the years to come, will continue to make a difference.
Judge, you mentioned that the upfront coordination consultation between the parties is very helpful. Now, when I listened to Steve indicated that this prompt is very important. It controls what you're looking for. If I'm looking at the TAR experience, and why I understand that everybody uses it, but they don't use it. They use it as a tool, but they don't use it for production. Keywords are still the predominant one tool in producing the documents that have been keyword and called otherwise, and at least mass-tort MDLs. So I'm looking at what is the resistance, what caused that resistance to using TAR, and what I hear from the lawyers is that, well, we weren't involved in the actual training, and we don't trust, and we don't know what went into it. Do we face the same problem here with AI with these 4 prompts? But you do mention that if we can consolidate, you mentioned there's 4 categories, and their relevance criteria, issues, case summary, key documents. Maybe some of those the parties can consult with and help this process.
Well, I'm sure those things are negotiated at the front end, but when you get into AI prompts, and Steve said this, if you think of AI in its simplest terms, it's like an automated review team. And what clearly is, in my view, work product confidential. This certainly gets into the theories and the mental impressions of the lawyers, would be, if you had human reviewers, what you would put in the review memo. Review memo, isn't 5 or 6 sentences, it can be pages and pages of the lawyer's view of what that litigation is about. And I'm not aware of any case law where a judge has forced a party to produce to the other side the review memo. I think the same applies to a prompt. And yes, you have those things, for example, in relativity error, the jumpstart things. But, that's the beginning, where you get into the issues and the lawyer's theories on the issues. That's where it's information that just is not going to be shared with the other side. And I don't think many judges are going to make lawyers share that. And, when you come up with a prompt, and I guess the other speaker sort of touched on this, and you use AI, you don't just come up with a prompt and then push a button, and then out on the other end, you have the review. There's, in the workflow, there's several samplings, and lawyers are constantly tweaking the prompt, because if you put in a prompt and you have all the, the jumpstart things, but then you get into the issues and the theories of the case, and then you look at a sample of what you're getting, and you're not getting the correct stuff, you're going to tweak the prompt. And then you're going to work with it. And then when you feel comfortable that you're getting to the important information, then you're going to run that against the whole set. So that's where I really think there isn't a lot of opportunity for, quote, cooperation between the parties. Where you can have cooperation, I know John doesn't like to hear this, but where you can have cooperation, is possibly sharing some sampling from your not relevant, your null set with the other side, and then certainly providing metrics to the other side. That can go a long way in giving the requesting party, usually the plaintiff's bar, some comfort that indeed they're getting what's necessary. Where the real disputes come down is, I think, at more of the macro level, and this is where proportionality comes into play. One side says, for custodian to say, well, we need all the information from the sales force to see what criteria they relied on. And the producing party says, well, we'll give you all the regional sales manager information. We've got thousands of sales managers throughout the United States, and that's going to be largely duplicative. And then the requesting party says, well, I understand it may be duplicative, but it's our view that the decision-making, which we think is relevant to the issues in the case, was made at the local level. We want all the local sales agents to have a dispute, and that's something that the parties would argue before the court. But once you get past that, and you've agreed on what might be that relevant universe of documents, that's really where the requesting party is not going to have as much iterative input as you do at the larger level.
Let me ask you a granular question. If a party came up to you and asked which search tool the defendant used, like they usually do in TAR, they usually ask, are you going to require direct the defendant to answer that or not?
Yes and no. I think under the rules, I technically don't have the authority to order a party to do that, but as a practical matter at a case management conference, I'm going to get the parties to talk about that. And professionals that do this every day are going to talk about it.
So to me, that brings you back to the problem we have with TAR. That's exactly what happened in the TAR experience. And once they talk to each other, the players then start saying, well, we want to get involved. And sometimes the judge agrees with that. Sometimes the judge doesn't agree with that. And that's why the defendants say, all right, we're just doing keywords.
Right. There's certainly some of that. Certainly with TAR, where there were problems, but where there were disputes, is the requesting party wanting to have input in defining the seat set, which
Right.
is obviously of some importance. But one thing John said, which I think is correct, I'm not a technologist, I'm not an eDiscovery expert, but I would say, I talk to my colleagues all the time, I would say, in at least the large cases, TAR is being used in most, if not all, big cases. And now we're seeing in the last year or so, AI is really becoming a tool of choice for review, and for two reasons. One, like I said, great recall rate. It can be the human review team, hands down. And of course, outside counsel, they have to be responsive to their clients, and their clients are all asking that. They're not asking outside counsel, are you using AI? They're telling outside counsel, you're going to be my outside lawyer, you must use AI, because the clients recognize there is savings in cost and efficiencies in using AI. So I think that's really the trend, and what's going on is we're seeing more and more use of AI. The lawyers like it. It works well, and the clients are, in many cases, insisting on it.
Well, let me get back to the crossroads theme that had originally, and that is as ESI data on sources grow, what are your expectations? Do you think the AI will be used to narrow the search to documents that are truly useful and not cumulative in resolving the issues? Or do you think it'll just be used to find more relevant documents faster and more accurately?
That's a good question. I was at a conference last week, and one of the lawyers suggested that since AI can significantly cut review costs and can conduct a review with a higher recall than a human review, defendants will now be producing more documents than before. A footnote, this is a lawyer that is on the plaintiff's side. I don't think that's necessarily true. Ultimately, efficiencies will be increased, costs will be reduced, and I think you'll get more focus on the documents that are produced, but you can't lose sight of the fact, and John mentioned this, on the back end, the requesting party has the same tools. So the requesting party doesn't need to have 60 lawyers sitting going through every document. They can use AI, and where AI is really good is for targeted production. It's great in government investigations, but when you're the receiving party and you've got the production, you can use AI to really focus in very efficiently and very cost effectively in finding documents that will support very discrete issues. So I think you're going to still see a lot of the reliance on the ability on the back end to look at these documents. So there's going to be less objections from requesting parties receiving the documents about, quote, document dumps. And I don't think document dumps really happen much, if at all, anymore since we've had TAR and certainly since we've had AI.
Thank you very much, Judge. We have just a few moments left. I'd like to address this question to Steve and to Aaron, and that is if the agreement is that we don't want to touch or don't want to have both parties develop the prompt at the front end to give confidence to the plaintiff that the search is getting the information that they think is important. If we don't do that, then it makes the validation process extremely important. Then the plaintiff only way to be certain that they're getting the information that they believe is important in their case is if the validation is strong. Now, there's validation process now, a process we have the best practices, random sampling. I'm wondering, Steve or Aaron, do your programs enhance any of the validation automatically? Is there something in addition to what the current procedures are, which some people would say is adequate? But what do you guys say?
Well, I'll start and then I'll defer over to Steve. I think there are two hard truths in agentic AI, and one is that you can't automate away accountability, and the other is that you can't automate away validation. So you make validation easier, you can put more rails on it, you can improve the process, you can make it faster, but you can't automate it away. At the end of the day, the human who is accountable for the producing the documents is going to do the same thing in terms of ensuring that they understand and they're confident in how the validation was done. I will sort of add one quick thing though before I turn it over to Steve, which is that something that we do have with generative AI that we didn't have before with TAR is that you have a better view up front without much cost of what the production will look like, how many documents will be produced. And that is something that actually gives, I think, the requesting parties a great deal more comfort. It's like, well, we know the process is going to have this recall and that they're going to be about this many documents, which is something that came with keywords, but was harder to get with TAR. Okay, over to Steve.
I would agree with all that. And I would just add that, as we talk about black boxes and so forth, TAR gives you a document ranking of 32 or 67 or 98. That's what you have. And if the document's not produced, and you have a motion to compel or problem, and it's got a score of 32, figuring out why it has a score of 32 is really hard. And so I don't think it matters what Gen AI is doing. The question is it doing it? And the difference here is it's telling you what it did. It's saying the document is no because it fails to meet X, Y, and Z, or it doesn't include this or that or that. It's actually a lot more transparent than TAR, and therefore it is enhanced in terms of the validation. We know exactly why a document was called relevant or not, and that allows one to adjust for it or to explain it or to just have comfort with what it's doing.
Before I turn it over to Tim to close this out, I just want to express my gratitude to the panelists for a rewarding discussion. I also want to thank Tim at TCDI for co-hosting this series of webinars. TCDI is the sole patron of the center, and its support has been critical to our success. I hope all of you have an opportunity to review the recordings and transcripts of our 3 webinars, including the first 2 featuring 2 former chairs with the Advisory Committee on Civil Rules. They're posted on the center's website at Rabiej Center /events and past events. You will find not more profound or insightful statements on the current state and future of eDiscovery. I want to thank you all, and Tim, for some final words.
Just thanks to John, the moderator, and the panelists. Great discussion. And thank you for the attendees for spending the time with us. Have a good day.
Take care.